We are live.
Okay, good afternoon, everyone. This is the session on the annual ADR case law update. I'm Larry Saylor. I'm a senior principal at Miller Canfield and longtime commercial litigator and AAA arbitrator. With me is Lisa Timmons, who's needs little introduction in this format. She's incoming chair of the ADR section and the executive director of the Mediation Tribunal Association. She was a very great student at University of Detroit Mercy School of Law, where I was fortunate to have her in a class. So welcome all. I'm going to be covering the arbitration case law, and Lisa is going to be covering case law and other developments related to case evaluation, mediation, and settlement agreements. And I'm going to start with 4 cases decided during the past 12 months by the U.S. Supreme Court, which has taken a pretty significant interest in arbitration over the past few years. The first of those was Coinbase versus Susky. That's a unanimous decision from May of 2024. The court has previously held that parties can expressly agree that an arbitrator is to decide questions of arbitrability. For example, you can incorporate the AAA or the JAMS rules into your arbitration agreement, which provide that the arbitrator is to make those decisions. But in the absence of an express agreement to that effect by the parties, the question of whether the case is arbitrable at all has to be decided by a court, not by the arbitrator. And in Coinbase versus Susky, the parties entered into 2 agreements. One provided for arbitration with the issue of arbitrability to be decided by the arbitrator, and the other was silent. The court held that in that circumstance, the issue had to be decided by a court, not by the arbitrator. And incidentally, I'm going to be, there are materials available on both in the chat and in the main webpage by both Lisa and myself. And in order to save time, I'm going to be just referring to the cases by name, but the citations of the cases are available in the materials, so you don't need to write rapidly. The next case that the Supreme Court decided was Coinbase versus Bielski in June of 2023. The Federal Arbitration Act, Section 16, allows an interlocutory appeal from an order declining to enforce an arbitration agreement. And the court, in that case, 5-4, held that the district court must stay proceedings in court pending the conclusion of the arbitration. And there's an interesting, very textualist dissent by kind of a surprising cast of characters, Justices Jackson, Sotomayor, Kagan, and Thomas, who concurred in the dissent, saying that really that's not based on the statute at all, but is more of a public policy argument that should be made by Congress. The next case is Smith versus Spizzirri, decided in May of 2024, back to unanimity by the court. In that case, the district court had ordered arbitration under Section 3 of the Federal Arbitration Act, which allows for allows the district court to order arbitration in a pending case, a case that's pending in the federal court. And the court, what the court held was that in that circumstance, the case has to be stayed rather than dismissed. And the court comments that one of the reasons for the stay is to allow the court, then the district court, to enforce the arbitration award after the arbitration is completed. That comment by the court potentially creates some confusion with a 2022 decision of the Supreme Court, Badgerow versus Walters, which held that under Section 4 of the Federal Arbitration Act, which allows the court to rule on a petition to compel arbitration where there is no pending case. To look through the petition, look through the case to determine if there's an underlying federal case, an underlying federal claim being advanced in the arbitration, and if so, the court has jurisdiction. So there can be diversity jurisdiction, or there could be federal question jurisdiction based on the underlying claim. But held the court in Badgero, there is no so-called look-through jurisdiction under sections 9, 10, or 11 of the Federal Arbitration Act, which allow the court to either vacate, confirm, or modify an arbitration award. So you have this odd circumstance where the federal court may compel arbitration, but then may lack jurisdiction to actually enforce the award, and the parties will have to march off to state court for that purpose. It's a confusing circumstance, and it isn't completely clear whether that's the case under Section 3, where there was a pending federal case, but at least one circuit court, the Smart Sky case in the Fourth Circuit, has held that Section 4 and Section 3 have to be treated exactly the same. So in either case, the federal court may lose jurisdiction when the arbitration award absorbs the underlying claim, and it becomes just a question of case enforcement of state law of contract compelling arbitration. So a potentially confusing situation. And the last Supreme Court decision of the past year was Bissonette versus LePage Bakeries. The court there was faced with a circumstance where the employees covered by the collective bargaining agreement, by a arbitration agreement, were employed by a bakery. The argument was made that they were subject to the carve-out in the Federal Arbitration Act for workers engaged in interstate transportation. And the court held that that is right, even though they were employed by a bakery and not an interstate transportation company, they were nevertheless covered by that carve-out from the Federal Arbitration Act. There are a couple of decisions by the Sixth Circuit that I think are of interest to Michigan practitioners. In Schwebke versus United Wholesale Mortgage, the Sixth Circuit followed the 2022 U.S. Supreme Court decision in Morgan versus Sundance, which held that the right to arbitrate can be waived just like any other contractual right, and that there doesn't any longer have to be a proof of prejudice flowing from the waiver. And in Schwebke, the employer, the defendant in that case, filed affirmative defenses and participated in discovery for 7 months before it finally got around to demanding arbitration, and the Sixth Circuit held that that conduct was completely inconsistent with the reliance on the arbitration agreement and implicitly waived the right to arbitration. The other Sixth Circuit case dealing with arbitration was an unpublished one. There, the employer was a government contractor. It terminated a security guard for sleeping on duty. The arbitrator found that the employer had failed to establish factually that the employee had in fact been sleeping on duty, and changed the termination to a suspension. And on appeal, the employer argued that the collective bargaining agreement reserved the issue of sleeping on duty for the government, and the arbitrator, or the Sixth Circuit, held that the collective bargaining agreement was ambiguous, and that ambiguity had to be interpreted by the arbitrator and not by the court. Moving on to Michigan decisions, there were, as far as I can tell, exactly 2 published Michigan Court of Appeals decisions, and none by the Michigan Supreme Court during the past 12 months. The most significant of the 2 published Court of Appeals decisions is Kilpatrick versus Lansing Community College. In that one, the community college terminated an IT director after she gave a presentation criticizing a co-worker and then refused to cooperate in the investigation. The arbitrator found that the plaintiff was terminated without cause and therefore was entitled to severance benefits under her employment contract, but that the plaintiff failed to establish a prima facie case of sex discrimination. And in the course of doing that, the arbitrator excluded some evidence of some comparators. The Court of Appeals concluded that the exclusion of evidence was erroneous, but the error was not material enough to substantially change the outcome. And the court rather cogently set out the difference in the standard of review between a judicial decision and a decision by an arbitrator. And I'll quote it. An arbitrator's factual findings are not subject to review by this court. On legal questions addressed by the arbitrator, this court's review is not, strictly speaking, de novo, contrary to our review of a decision by a trial court or administrative agency. Instead, courts will not set aside an arbitration award unless the arbitrator committed legal error, and that but for such error, a substantially different award must have been made. So in the Kilpatrick case, the court confirmed or affirmed the order confirming the arbitration award. The other published decision by the Court of Appeals was Immersion versus North Brothers Ford. In that case, the plaintiff filed a putative class action complaint alleging that the auto dealer overcharged for aftermarket accessories. The circuit court granted summary disposition, enforcing the arbitration clause in the auto lease. Plaintiff argued on appeal that the arbitration provision was not enforceable because, one, the lease had been assigned to a finance company, and two, the claim was based on the accessory price sheet, not the lease, and the accessory price sheet didn't say anything about arbitration. The Court of Appeals affirmed the motion, the order of the circuit court, finding that the lease anticipated that it could be assigned to a finance company and that the claim was sufficiently related to the lease to be covered by the arbitration agreement. So this points up the need for a well-drafted arbitration clause. Moving to commercial law cases that are unpublished, an interesting one is Dow Chemical Company versus Aurea Solutions. That one was a battle of forms. The Aurea was a customer of Dow. It issued purchase orders that provided for arbitration under the AAA rules. But Dow then responded with invoices containing its own terms and conditions that conflicted and did not provide for arbitration. The Court of Appeals ordered arbitration, but the Court of Appeals reversed, holding that under those circumstances, this is similar to Coinbase versus Susky, the issue of arbitrability was for the court and not for the arbitrator. And the court found that Dow never agreed to the purchase order that actually contained the arbitration provision, and therefore that it did not apply. The next case is 1-800-Bathtub Inc. Versus Rebath. There, the plaintiff leased a 1-800 number to the defendant under a marketing services agreement. Defendant decided that the plaintiff was a hoarder of 800 numbers and decided to stop paying the plaintiff and contracted directly with the telephone company for the number. There, the Court of Appeals held that the arbitrator exceeded his powers when he awarded plaintiff damages for both breach of the marketing services agreement and conversion of the phone number. The claim, said the Court of Appeals, sounds in contract, and the separate and distinct doctrine precludes an award of damages for conversion, which is a tort claim. The next case is UHG Boca LLC versus Medical Management Partners. There, the plaintiff claimed that the operating agreement establishing the LLC defendant entitled it to share revenues from the defendant's patient billing. The arbitrator rejected plaintiff's claim under the wrongful conduct rule, finding that the billings were illegal and that the Fifth Amendment did not bar an adverse inference against plaintiff agents who asserted the privilege and declined to testify. The Court of Appeals affirmed. Under Mona versus Farm Bureau General Insurance of Michigan, the trial court entered a stipulated order dismissing plaintiff's auto insurance claim with prejudice pursuant to a binding arbitration agreement. The problem is that the parties never actually executed or drafted an arbitration agreement, but the court ordered the parties to select a neutral arbitrator. The Court of Appeals reversed, holding that the Court of Appeals was not free, that the trial court was not free to order the parties to select an arbitrator when they had never actually concluded an arbitration agreement. Moving on to labor and employment cases. One that's kind of on the racy side is Michigan Department of State Police versus Michigan State Police Troopers Association. There, a female trooper pleaded no contest to sexually assaulting male co-workers when she was intoxicated at a work party. The arbitrator found that the trooper's actions violated the Michigan State Police Code of Conduct, but that the trooper was discharged without good cause and therefore reduced the punishment to unpaid suspension and reinstatement with back pay. The trial court vacated the award, holding that the collective bargaining agreement vested the state police with discretion to determine the level of discipline. The Court of Appeals reversed, holding that the arbitrator's conclusions were within its authority. In other words, that the arbitrator was free to construe the collective bargaining agreement and that the decision of the arbitrator was not contrary to public policy. In Johnson versus Best Buy Company, the employee electronically clicked "I agree" when she completed her employment application online. And that online employment application included an arbitration clause. The Court of Appeals held that the employee was bound by the arbitration provision. Plaintiff was deemed to understand what she signed and that her public policy argument was for the legislature, not for the court. Moving on to family law cases. Beecham versus Beecham. The parties entered into a consent judgment of divorce that did not allow the arbitrator, that according to the trial court, did not allow the arbitrator to deviate from the Michigan child support formula. The Court of Appeals reversed, finding again that similar to some of the earlier cases, that there was an ambiguity in the consent judgment of divorce, but that where there is an ambiguity in an agreement to arbitrate, the issues have to be decided by the arbitrator. When an ambiguity may exist with regard to whether a specific matter falls within the scope of arbitration, that ambiguity is to be resolved in favor of submitting to the arbitrator. In other words, the arbitrator gets to resolve the ambiguity. And the court said any ambiguity regarding whether a dispute falls within the scope of an arbitration agreement is to be resolved in favor of arbitration. In Mann versus Whitfield, the circuit court entered judgment of divorce confirming the arbitrator's award. On appeal, after retaining different counsel, defendant argued that the arbitration award should be vacated under the domestic violence exclusion of the Domestic Relations Arbitration Act, and because the arbitrator failed to do domestic violence screening as required by the court rule, MCR 3.216. The Court of Appeals held that neither argument was preserved below. And in any event, both of them were without merit. The Domestic Relations Arbitration Act argument was without merit because the parties had signed a voluntary waiver, and the court rule applies only to mediators, not to arbitrators. Two more cases, and there are a few others covered in the outline that are not, that I'm not going to cover. Mazik versus Mazik. The order for arbitration there did not comply in multiple ways with the requirements of the Domestic Relations Arbitration Act, but plaintiff filed her objection more than 21 days after the arbitration award, and that violated MCR 3.602. And in any event, the court said there was no evidence the award was procured by fraud, corruption, or undue means, and therefore confirmed the arbitration award despite those problems with compliance with the act. Finally, in Shannon versus Ralston, the defendant had appealed 8 prior times from awards of child custody. The arbitrator finally, after those 8 appeals, awarded attorney fees to the plaintiff appeal. Awarded attorney fees to the defendant. The Court of Appeals held that the plaintiff waived her right to an evidentiary hearing before the arbitrator on the request for attorney fees, that an adequate record existed without a hearing, and that the arbitrator had authority to award attorney fees to the defendant. That concludes the cases I'm going to cover orally, and I'll turn it over now to Lisa.
Thank you, Larry. I am going to start with in the same vein that Larry did. I'm going to start with the United States Supreme Court case, and this dealt with settlement agreements, Harrington versus Purdue Pharma. So here the court addressed the legality of a non-consensual third-party release in a Chapter 11 bankruptcy plan. So this case arose out of Purdue Pharma's bankruptcy, in which the Sackler family, owners of Purdue, sought to secure a release from liability for opioid-related claims without the explicit consent of all the creditors. So in 2007, Purdue Pharma executives pleaded guilty to federal misbranding charges. Purdue Pharma was subject to thousands of lawsuits for its part in the opioid crisis. And after that, the Sackler family withdrew $11 billion from the coffers, which was 75% of Purdue Pharma's assets. Withdrew that in anticipation of Sackler family members being sued personally. Purdue Pharma filed for Chapter 11 bankruptcy in 2019 after the lawsuits and withdrawals from the Sackler family pushed the company to insolvency. So during the bankruptcy proceedings, the Sacklers offered to return $4.3 billion to the company's bankruptcy estate in exchange for a judicial order that would shield the family from all opioid-related claims against them. The order would have prohibited opioid crisis victims and their families from pursuing lawsuits against the family in the future, as well as protect the Sackler family from existing legal claims. Here, the bankruptcy court accepted the proposed settlement terms, but a federal district court vacated the order. The Second Circuit Court of Appeals reversed the district court's ruling and then upheld their original settlement. So then the case was appealed to the Supreme Court by the U.S. trustee. The Supreme Court overruled the settlement, holding that the bankruptcy court did not have the authority to approve that Sackler family settlement based on federal bankruptcy law. The court ruled that the bankruptcy code does not authorize a release and injunction that is part of a plan of reorganization, effectively seeks to discharge claims against a non-debtor without the consent of those affected claimants. And because the Sacklers were not named debtors in the bankruptcy case, they didn't have a right to seek immunity from opioid lawsuits in the Purdue Pharma bankruptcy proceedings. There was a strongly worded dissent. This was a 5-4 decision. So Chief Justice Roberts, Justices Kavanaugh, Sotomayor, and Kagan joined in this dissent, asserting that the majority decision is rewriting the text of the bankruptcy code, restricts the long-established authority of bankruptcy courts to fashion fair and equitable relief for mass tort victims. They also argued that the settlement plan was supported by most of the opioid victims' creditors, as well as all the state attorneys general. They wrote in their dissent that the decision almost guarantees denies relief to most of the creditors now because they felt that the Sacklers lacked any incentive to return that money back to Purdue Pharma. So a couple bullet points that this holding did not address. Sometimes these Supreme Court holdings leave more questions than answers. So it didn't address whether consensual third-party releases can now be included in Chapter 11 plans at all, and what qualifies as a consensual release for the purpose of a Chapter 11 plan, or whether a different rule applies when a plan fully satisfies claims against a third-party debtor. So next, I'm going to turn to the Sixth Circuit. Got two decisions the first one dealt with case evaluation. So this is versus Allstate. So this case arose from prior litigation involving an accident that occurred back in 2013. Meyer's motorized bicycle was hit by a vehicle. After the litigation ended in summary judgment, Meyer filed an action alleging that Allstate committed fraud and had conspired with state court judges to deny him due process. He specifically alleged that after the case evaluation panel unanimously awarded a case evaluation award in his favor, that in effect meant that the panel had awarded him summary judgment. So the Sixth Circuit found that the Case Evaluation Court Rule, MCR 2.403, does not require a trial court to adopt case evaluation outcome as binding. The court explained that while case evaluation awards may guide settlement discussions, they don't automatically control the final judgment unless both parties accept the evaluation, which was not the case in this case. Further, the court opined that a rejection of case eval does not mean that a rejecting party is not precluded from filing a dispositive motion or that the case automatically goes to a jury. So the Sixth Circuit also considered a case in Ward versus Shelby County in 24 that dealt with settlement agreement and release language. There, the court addressed whether a settlement agreement that included a broad release of any and all claims whatsoever effectively barred claims under the Uniform Services Employment and Reemployment Rights Act, also known as USERA, that were not specifically enumerated in the settlement language. So Ward was an Army reservist. He had been terminated by Shelby County and later agreeing to release in exchange for back pay and the opportunity to return to work. Years later, he brought this USERA claim alleging that the county violated his employment rights as a service member. So there the Sixth Circuit held that the law does not require contracting parties to enumerate one by one all the objects they intend to a particular clause to reach. When the parties intend to settle any and all claims, rather, the law allows them just to say that, precisely that. I am now going to move to a series of Michigan decisions that considered case evaluation. Relevant to this discussion is the fact that many of you are probably aware of that the case evaluation court rule changed drastically as of January 1st, 2022. One of the changes that's going to be pertinent to the line of cases that I'm going to discuss is the elimination of sanctions under MCR 2.4030. And before I walk you through that, there's two things that the appellate courts have considered about whether or not the old rule applies or the new rule applies, because obviously there were some cases that were already filed and pending previous to January 1st, 2022. And then there was either jury awards or MSD or something of that nature, some sort of dispositive ending to the case after the amendment of the court rule. So first I want to read in pertinent part MCR 1.102 that deals with effective date. And that rule reads that a court may permit a pending action to proceed under the former rule if it finds that the application of these rules to that action would not be feasible or would work in justice. So that last clause is going to be relevant, would work in justice. And to help illustrate that, I'm going to walk you back to a 1999 case, which is Reitmeyer versus Schultz Equipment and Parts. And this dealt with the change of the offer of judgment rule. So in Reitmeyer, the plaintiff filed for a motion of offer of judgment for sanctions and attorney fees after obtaining a favorable jury verdict that exceeded the last offer of judgment. Plaintiff there claimed he was entitled to costs and attorney fees because before the amendment of the court rule, the offer of judgment rule allowed for the award of costs and attorney fees when the adjusted verdict was more favorable to the offerer than the average offer. There, the trial court denied plaintiff's motion, stating that there was no clear intention by the Supreme Court that that rule as amended would operate retrospectively. So on appeal, the Court of Appeals held that a court may permit a pending action to proceed under the former rule if it finds that the application of these rules would not be feasible or would work in justice. Again, that's that clause. And so the court opined that an injustice is not merely present, however, because a different result would be reached under the new rule. So the court established a test that would be applied, that's going to be applied to these 23 and 24 cases that I'm going to walk you through. And the new rule would, opining that a new court rule would work in justice where a party acts or fails to act in reliance on a prior rule, and the party's action or inaction has consequences under the new rule that would not have been present under the old rule. Okay, so with that in mind, turning to the case evaluations decisions that were decided post January 11th of 22 for the amendment. The first one that dealt with case evaluation, not too meaty, but I'm just going to name it. It's Rad Construction versus Davis. This was decided on August 10th of 23, and there the Court of Appeals reversed a trial court award of case evaluation sanctions after the court rule amendment date. That court applied Reitmeyer and MCR 1.102, finding no injustice, and the court wrote that there was no reason to apply the old court rule in this case. One that is a little bit more nuanced was Knight versus Green. This came out October 19th of 23. This case involved the application of case evaluation sanctions under the previous version of MCR 2.4030, the sanctions. When the former rule was still in effect, plaintiffs filed their motion for case evaluation sanctions, and the trial court entered its award, awarding those sanctions. In a motion for reconsideration, defendants for the first time, challenged the case evaluation award of sanctions. The court there held that defendants did not raise this issue objecting to sanctions until they filed a motion for reconsideration. And that motion for reconsideration was on January 14th of 22, which is what, about 60 days, but about 6 weeks rather, after the amendment. And therefore, the court ruled that they failed to properly preserve the issue of sanctions. Another case that considered Reitmeyer was Block versus Hizak. That was November 21st of 23. Here, a plaintiff claimed an injustice because she effectively had a vested right in case evaluation sanctions before the court rule was amended. So the court opined that this argument miscomprehends the case evaluation process. And their holding was that contrary to plaintiff's argument, any right that she had to collect a case evaluation sanction under the former rule didn't actually accrue until after she had outperformed the award. So it wasn't the award itself, it's the outperformance of the award. Thus, at any time the amendment became effective, it was entirely possible that plaintiff would never gain a right to collect those sanctions. Even under the former version of the rule, the court wrote that plaintiff's right to case evaluation sanctions would not have vested until the jury returned its verdict, which in this case came after the rules amendment. So in this case, the court, applying Reitmeyer, held that an injustice is not present merely because a different result would have been reached under the new rule. Another case that applied Reitmeyer again is Webster versus Oglethorpe. This is December 21st of 23. This is a case where a dentist appealed a judgment for plaintiff, entered after a jury trial, awarding plaintiff damages of $565,000 in a dental malpractice action, and additionally awarded plaintiff attorney fees of $169,000 as case evaluation sanctions under the pre-amended version of the court rule. So the Court of Appeals reversed and vacated the award for case evaluation sanctions, holding that the case evaluation award in this case, so they had gone to case eval, and the case evaluation award in this case was actually $199,000. Plaintiff had accepted that award and defendant rejected. So the court wrote that even though plaintiff may have been willing originally to accept award of $199,000 rather than risk going to trial and receiving less than they would have preferred to avoid that added expense of trial, the consequence of going to trial ultimately worked to plaintiff's financial benefit. And even though the added expense of going to trial was being considered, under these circumstances, the court ruled that the application of the former rule was not necessary to avoid an injustice to plaintiff. Next case I have is McHenry versus Farm Bureau General Insurance. This is a 24 case, Michigan Court of Appeals. So here in 2018, McHenry was a pedestrian. He was struck by a motor vehicle. He sought PIP benefits from his carrier, but the claim was denied after an investigation. McHenry filed suit seeking the unpaid PIP benefits. At trial, the parties disputed whether McHenry's injuries resulted from the incident and whether he had made material misrepresentations concerning his claim. So at trial, he was awarded a jury verdict of $137,000 and some odd $261. On appeal, the Court of Appeals held that the trial court erred by awarding plaintiff attorney fees as a case evaluation sanction on top of the jury award. McHenry argued that applying the current version of the case evaluation court rule after post amendments would work an injustice because he had relied on the potential for case evaluation sanctions when he made the strategic decision in the case, such as the decision to proceed to trial. So again, the court considered Reitmeyer, where a new rule, again, would work an injustice where a party acts or fails to act in reliance on the prior rule, and where the party's action or inaction has consequences that were not present under the old rule. So there the court opined that even though this case was tried in January 22, which is really close to the amendment time, that the amendments to MCR 2.403 were being considered publicly by the Supreme Court in hearings and public testimony for months prior to that amendment. And the court opined that McHenry should have been aware that the change was basically in the works to the court rule before he made a final decision to proceed with trial. Therefore, their holding was that the trial court erred by granting attorney fees as case evaluation sanctions under the pre-amendment version of the court rule. Another case, last case that I have in the lineup for case evaluation is Pack versus JJ Development. So this came out August 1st of 24. And here the court addressed an order denying a motion for attorney fees and costs as case evaluation sanctions. The court rule applied the amended version of 2.403, denying the defendant's motion for sanctions, reasoning that applying the old rule would work an injustice since the claims decided by the jury were not part of the original case evaluation. The trial court noted that a significant portion of the defendant's legal fees related to defending claims weren't included in the case evaluation. The defendants appealed, arguing that in this case, the former rule should apply, but the appellate court affirmed the trial court's decision, emphasizing the need to apply the current rule unless doing so again would work an injustice. In a dissenting opinion, Judge Jansen argued that in this case, the trial court should have applied the former version of 2.403 because the defendants were subjected to frivolous litigation without a viable cause of action against them. Next, I'm going to turn to a line of cases that discuss offer of judgment. So just to refresh your memory, under MCR 2.405, offer of judgment is being used with greater frequency because of the removal of case evaluation sanctions. And that rule in pertinent part says that any party may serve an adverse party with a written offer to stipulate to an entry of judgment in a sum certain. Additionally, any party may make multiple offers of judgment. So there is an interest of justice exception as part of that court rule that states that the court may, in its interest of justice, refuse to award an attorney fee under this rule. So the court has considered that the award of attorney fees under MCR 2.405 should be the rule rather than the exception. And economic disparity between the parties doesn't warrant applying the interest of justice exception, nor does the fact that the offeree's rejection may have been reasonable or that its position wasn't frivolous. Finally, the interest of justice exception requires unusual circumstances, such as few situations will justify that. For example, the exception may be invoked when a party makes a de minimis offer of judgment early in the case in the hopes of tacking attorney fees to costs if successful at trial. One of the first cases that explored this interest of justice exception was Capello versus Walton. This was decided on March 28th of 2024. And there the court considered the interest of justice exception to the offer of judgment rule, holding that plaintiffs were not entitled to the interest of justice exception because the defendant's offer was made at a point in the litigation when it was clear that they would prevail at summary disposition. Moreover, the record suggests that the protracted litigation in this case was a result of plaintiff's personal vendetta against defendants rather than a defendant's unwillingness to settle the case. Next, I'm going to move to mediation, and my first case in mediation is a labor and employment case. This is Nope versus IHA Health Services Corporation. This was decided September 14th of 23. This arose from defendant's termination from plaintiff's employment. So here plaintiff argued that the trial court erred by failing to interpret provisions of a contract to mediate and to supply 120 days of notice as a condition precedent as opposed to a promise. So plaintiff argued that without meeting these conditions first, defendant did not have a right to terminate him. The court noted that the mediation clause at issue stated that both parties agree to act in good faith, to preserve and maintain the relationship, and to use mediation and alternative dispute resolution approaches as needed. So the court ruled that the phrase agree to act makes it clear that this is a promise explaining how the parties are expected to act and not a mere condition. The parties promise to act in good faith to preserve the employment relationship, including the use of mediation and ADR as needed. In other words, this promise created a right or duty according to the court, and it was this promise that the trial court determined that defendant breached. The final holding was the trial court did not err by characterizing the provision as a promise or covenant instead of a condition. I have a family law case next that dealt with mediation. That was Simmons v. Simmons, Michigan Court of Appeals, May 16th of 24. This addressed the enforceability of a mediated settlement agreement between the parties in a divorce case. Here, the parties upheld the settlement, noting that it met the requirements under Michigan law, specifically MCR 2.507G, which mandates that agreements reached in mediation or otherwise are enforceable if they are in writing or made in open court. So next, I have a line of cases that deal with settlement agreements. And first is a general civil case. This is Smith v. Forrest, decided January 4th, 2024. Here, the Court of Appeals dealt with the validity of a confidential settlement agreement, a CSA, and a release. The court held that a release as part of a CSA could not waive claims of fraud or breach of fiduciary duty if those claims challenged the formation of the agreement itself. The court found that a factual dispute remained regarding whether the defendant's actions constituted fraud, and thus the trial court erred in dismissing these claims based on their release. Next is Wilcoxon v. Fletcher. This also addressed the enforcement of a settlement agreement under MCR 2.507G. I'll read it quickly for you. It states that an agreement or consent between the parties or their attorneys respecting the proceedings in an action is not binding unless it was made in open court or unless evidence of the agreement is made in writing, prescribed by the party against whom the agreement is offered or by that party's attorney. So key to this case is going to be that last section, by that party's attorney. So here the court upheld the trial court's decision finding that a valid and binding settlement agreement existed between the parties. Defendant moved to enforce the settlement agreement, which involved a payment to plaintiff, and both the parties' attorneys had acknowledged the existence of this agreement in their filing, satisfying the requirements of 2.507G for a binding settlement. So plaintiff argued that the settlement was invalid due to fraud committed by her attorney, who she claimed entered into the settlement agreement without her authorization. So the court held that any fraud committed by the person's attorney did not invalidate the settlement. Instead, the proper remedy for such a claim would be a legal malpractice suit against the attorney, not the setting aside of the settlement agreement. As such, the court affirmed the settlement as enforceable, and there was no basis for relief from judgment. Just quickly, I'm going to go through. I have a couple more cases. I think I'll be able to make it. I've got a probate case, Conley v. Conley, Michigan Court of Appeals. This came out very recently, August 22nd of 24. The Michigan Court of Appeals upheld a probate court's decision that terms of a settlement agreement governing a trust were unambiguous and had not been breached. So this involved siblings, part of a trust administration arguing that one of the siblings had breached her duties under the trust. The court ruled that the settlement terms were clear. There was some capital gains taxes that were a natural consequence of the assets, and therefore each party was responsible for their obligations, and there was no breach of the duty. Last two cases are real property cases, just very quickly. They both came out the same day. One is Wells Fargo Bank versus Banks, and the other is Garst 3G Property Management. They both came out August 25th to 24. So in the first one, in Wells Fargo, the court emphasized the enforceability of a settlement agreement, noting that it's a binding contract. Explained that an agreement to settle a pending lawsuit is a contract to be governed by legal principles applicable to construction and interpretation of contracts. And then in Garst versus 3G Property Management, that one again focused on the interpretation and enforcement of the settlement. That one revolved around a dispute involving a condition precedent, which was stipulated to be a property conveyance. The court held that the condition precedent was satisfied as required by the settlement agreement, and defendant had argued that it wasn't, just real quickly, that the settlement was not fully settled because the purchase occurred in the context of a bankruptcy proceeding, and the term settled hadn't been properly defined. The court rejected that argument, noting that the settlement agreement was clearly defined and did not require anything formal for formal documentation other than was already in place. So with that, thank you. Larry, I'll turn it back over to you for any closing remarks.
All right, thank you, Lisa. You know, we have maybe a few minutes if I can figure out how to unmute everyone. If there are any questions or comments.
Yeah, we do. If you could take yourself off mute, probably, if you have any questions, or put them in the chat and then I'll read them.
And I'd also remind everyone to complete the evaluation forms after all the sessions are done.
Okay. And so since I don't see anything, I do want to add that Larry Saylor has been very modest. Next week is our awards dinner on the 26th. I hope everyone can attend because Larry will be receiving the Hero of ADR Award. He has been instrumental in our Skills Action Team in bringing forth all the programming that you've seen, not only at our annual meeting, but our Lunch and Learns. And we're just very grateful for all the the time and energy and expertise that Larry has put into these. So I see Kyle said that you can unmute now. So if anybody has anything quickly they want to add in the last minute.
Thank you, Lisa.
Okay. All right. Okay, I don't see
Yeah.
anything, so I'm gonna tell everyone thank you, and I will let you get started and go on to your next program. Thank you for joining us
Yeah.
and
Yeah.
participating.
Thank you all.
Okay, take care.